Well, welcome back to day two of the Corporate Counsel CLE marathon of 12 hours of CLE in 3 days. And we are so grateful that y'all could join us. We have a great day lined up. And just as a reminder, we'll go from 12 to 2, and then we'll take a break, and then we'll go from 3 to 5 today. And if you have questions, you would want to submit those in the Q&A using the Q&A button on the bottom of your screen, or at least on the bottom of my Zoom screen. And with that, I'm just going to go ahead and kick it off to you, Kim, and let you introduce your panel. We're looking forward to hearing about the U.S. Supreme Court.
Thank you so much. We appreciate everyone for joining us this afternoon, and I especially appreciate our distinguished panelists for agreeing to participate in this afternoon's discussion. In alphabetical order, first I would like to introduce Justice Keith Blackwell. He served on the Georgia Supreme Court for more than 8 years. Prior to that, he was a judge on the Georgia Court of Appeals. And during his term of judicial service, he authored more than 400 published opinions. So as you can tell, he's not opinionated at all. Prior to his judgeship, he was in private practice, and he also served as a prosecutor in Cobb County. He currently serves as an appellate guru at Austin and Byrd. And my favorite fun fact about Justice Blackwell is that he is a double dog, much like myself, meaning he attended law school and undergraduate school at the University of Georgia. Thank you, Justice Blackwell, for joining us.
Thank you.
Next, I would like to introduce Mr. Jack Cohn. He is the co-chair of Gordon and Reese's National Appellate Practice Group. He has more than 30 years of experience in all aspects of trial and appellate practice, including the distinction of having argued before the U.S. Supreme Court. He has obtained precedent-setting results for clients in areas such as insurance coverage, bad faith, class action defense, bankruptcy, civil rights, and constitutional law. He's also admitted to more courts than I care to recite. He has been named to the best lawyers in America in appellate practice, and he has the distinction of having attended undergraduate school and law school at the University of Pittsburgh, which I guess makes you a double Panther. I'm not sure how that works.
Except I did my undergraduate at the University of Pennsylvania, but that's fine too.
Oh, I'm sorry about that. Almost. Thank you so much to both of you again for joining us here today. And I am going to pull up the presentation. One second. So thank you so much. Before we get started, we just want to kick off with an overview of the court and its current composition. There is a 6-3 conservative majority currently in the court, and the justices on this slide are listed in order of tenure. With one exception, there is an error in this slide. Activate the brain cells. If you know what is wrong with this list, please put it in the chat right now. I would give you Jeopardy music, but I don't have any, so I'll give you about 5 seconds to look over this list and tell me what you think the error is. If you said that Justice Clarence Thomas is the longest tenured currently sitting U.S. Supreme Court justice, then you are right, and you earned a gold star for today's presentation. He was confirmed in October of 1991, so we've had almost 30 years, a little over 30 years with Justice Thomas on the bench. Chief Justice John Roberts is listed. He's sitting as chief. The most recent justice to be added to the Supreme Court is Justice Amy Coney Barrett, who was confirmed a little over a year ago. In recent times, we have talked about the Supreme Court, I feel like more than ever, and the Supreme Court is now talking back. During the past several months, 4 out of the 9 sitting Supreme Court justices have all made public statements in defense of the political independence of the court. Well, why is that? According to a recent Gallup poll, approval of the US Supreme Court is down to 40%, which is a new low as compared to the past several decades. What explains that dip in public approval? Most sources would say it's the view that the court is now partisan. And in that conversation, inevitably, we talk about the appointment process for Justice Amy Coney Barrett. In fact, there are still very strong feelings about her appointment process. On the 1-year anniversary of her confirmation, Senate Democrats released a report entitled Captured Courts. And that report purports to show how special interests used money to solidify conservative control of the Supreme Court. We won't go into that, but that is linked to our written materials for your perusal. Also a part of the view that the Supreme Court may now be partisan is certain controversial decisions and/or inaction. For instance, allowing the Texas abortion law to take effect, blocking the Biden administration's attempt to enforce the latest federal moratorium on eviction. All of those things are part of the conversation. One of the other important components of what is viewed as partisanship is the court's increased use of the shadow docket. If you're like me and you hadn't heard that term until perhaps the last, several years, but the shadow docket just refers to decisions outside of the regular oral argument schedule. And that's increased dramatically in recent years. From 2005 to 2014, there were approximately 6 shadow docket opinions per year. In the last 2 years, there's an average of almost 18 decisions. So I want to get our panelists involved in this discussion. And I'll start with you, Justice Blackwell. Just say, what do you make of all of the media attention surrounding whether or not the court has become partisan?
Thanks, Kimberly. To begin, I will observe that there have been allegations throughout the history of the Republic that the Supreme Court is too political, is too partisan. If you look back to the wrangling in the early days of the Republic between John Marshall and his Federalist contingent on the Supreme Court and the Jefferson administration and the other early Democratic Republican administrations after the Federalists lost in the election of 1800, the Supreme Court's battles with President Jackson, the Dred Scott decision, which led into, of course, the Civil War, the back and forth between the Supreme Court and President Roosevelt in the Great Depression with respect to his New Deal programs. And folks on this program who are old enough can probably remember maybe when in the 1950s, you might drive around the South and see impeach Earl Warren signs all over the place. So the fact is, this is not a new phenomenon. I think the court is right to be concerned about it. The court needs to maintain at least some measure of public confidence in what the court does. And so I think that's why you see some of the justices speaking out. I think they also see some institutional threats being floated by some folks on Capitol Hill who would change certain longstanding practices at the court in a way that might be appealing from the outside, but probably might be detrimental to the long-term operations and health of the institution. And so you see that. in any event, I think some of the attention that's being given this as if it's something new in the history of our republic is a little bit overblown.
Got it. Mr. Cohn?
So the process of seating judges is what has become far more partisan. And that is a phenomenon that started, I think, most obviously in 1987 or so with Judge Bork. And it continues. And I think that the political games that go on and the maneuvering has given rise to a perception of partisanship. But judges have always come to the bench with their views and life experiences. And when you win elections, you get to try to put people on that you think share your views and life experiences. Judge Aldiser, late Judge Aldiser from the Third Circuit, used to write in some of his opinions, we must never forget as judges what we know as men and women. And that holds true. And I agree with Justice Blackwell that there have been times throughout the history where there has been much greater political tension. There has, in fact, been a lot more of justices having dinner with the president to talk about cases that went on. And like President Johnson putting his buddy on the bench. But the bottom line is that it used to be that if you had a qualified judge that was not completely off of the, intellectual ideological reservation, you were allowed to, that judge would be confirmed as a justice by the Senate. And that has changed. And when you look back to Alito and the chief, there was a lot of screaming and moaning that they were too conservative. And I said to my friends, win elections. If you don't like the qualified people that the other side puts up, win elections and put your people up. But I don't think that the institution itself is fundamentally more partisan.
Thank you. What of the increased use of the shadow docket? Just saying the word shadow docket makes it sound nefarious, but what is your take on that?
Well, let me go first on this one, because shadow docket, it is pejorative. There's always been the emergency docket. There's always been death penalty cases. There's always been things that you want to enjoin. But I think two things in the last 5 years have led to the explosion. And one is the prior administration's very expansive view of executive power. And you had a host of appeals and trying to stay things from bans from people from certain overwhelmingly Muslim countries, to the southern border immigration things, to what census questions are going to be asked. And then, of course, we've had COVID, and COVID led to a ton of restrictions, a ton of challenges. You can't go to church. Okay, there's a religious challenge. And I think that those are the two things that have driven the significant expansion in the last 5 or 6 years.
And Jack, I think you're exactly right. I would add one more factor to that, which is the increasing prevalence of nationwide injunctions issued by district courts. You really didn't see that occur with much frequency at all, except in true class actions, up until really about midway through the Obama administration. And it was at that point that some of the Republican state attorneys general started filing lawsuits to try to shut down initiatives of the Obama administration. And when they would find a friendly district court judge, you get a nationwide injunction. The sides, everybody changed sides when President Trump was inaugurated, but that practice continued of people seeking nationwide injunctions against federal initiatives. And they've switched sides again now, and it is continuing with the Biden administration. And so when you have a traditional injunction that just prohibits the federal government from enforcing a new executive policy against an individual or a discrete group of individuals, that's one thing and probably doesn't demand the U.S. Supreme Court's attention. But when you have prohibited the federal government from implementing a policy that the president has signed off on throughout the country, that is a matter of national importance. And I think it's probably fitting in most of those instances that the Supreme Court at least take a look at it when they're asked to.
Thank you. I appreciate that. So one of the things, Justice Blackwell, that you referenced was challenges potentially to the institution of the Supreme Court. President Biden instituted a 180-day commission to study potential expansion of the court. And it was to look at 4 key areas: membership, term limits, court's role in the constitutional system, then docket rules and practices. I was so hopeful that the final report would have been published by the time we had the opportunity to have this conversation. But alas, we shall have to wait until next week, until December 15th, to hopefully see what that report looks like. A point of Supreme Court trivia, though, Congress can and has changed the number of justices appointed to the Supreme Court. The United States has held constant at 9 justices since approximately 1869, though, so any change would be significant. So all of this means that we are due for a very exciting 2021 term, which began officially on Monday, October 4, 2021. Supreme Court terms begin first Monday in October. And during this hour, I want to discuss with you some of the important decisions from the 2020 term and also look at what is next. Just to provide an overview for context of the 2020 term, there were approximately 62 cases that got oral argument, 67 opinions. The largest number of cases came from the Ninth Circuit, which should be no surprise. That's been the case for the past decade or so. Cases from the 11th Circuit, 4, not that many, but significant. Also, as a resource, we should mention that the Harvard Law Review publishes a great statistical analysis of the Supreme Court's opinions from its most recent term. You can sort for things like voting alignments, 5-4 majorities, the disposition of emergency applications. So anyone who wants to check that out after this conversation should definitely do so. And there have been a number of important decisions in the October 2020 term, and we will not read to you from these decisions. But please peruse our written materials to get to some of the cases that we won't have an opportunity to discuss. You'll find cases that touch on the First Amendment, the Voting Rights Act, Obamacare. There's just a ton of cases there. What we really want to do during our time here this afternoon is to hone in on those decisions that really focus on and affect business. So the first case that we are going to discuss is Cedar Point Nursery versus Hasid, which basically held that California can't require union representatives to be allowed to meet with farm workers at their work sites because to do so violates the constitutional rights of employers. Justice Blackwell, if you would, give us your synopsis of this opinion, but also how it impacts regulated business.
Sure. So Cedar Point, I think, may actually, in the long run, we'll have to see what the lower courts do with it and what the Supreme Court does with it when they next visit this issue. But I think it could turn out to be certainly one of the most consequential decisions of the last term, and perhaps the most consequential decision. The case arose out of California, where there's a California state labor law that required that labor at a business have a fair opportunity to organize. And in a regulation issued pursuant to that statute, a California regulatory agency required that businesses, agricultural employers having so many employees, were required to give access to union organizers, access to their premises for union organizers for, I think it was 3 hours a day for 120 days of the year. You've got to let the union organizers come on your premises and talk to the employees about organizing during that period. So Cedar Point Nursery is, I think they're a strawberry grower. They filed a lawsuit to challenge the regulation on the basis that it was a taking of their property without just compensation. Takings clause of the Fifth Amendment, of course, requires that any taking of private property for public use the owner of the property has to be given just and adequate compensation. So there have always been a couple of different kinds of takings. There are a number of takings that qualify as per se takings. That is when the government exercises eminent domain and actually takes title to your property. It's when the government actually comes in and occupies your property. Those would amount to per se takings. There are also regulatory takings that oftentimes are governed by a test called Penn Central. That's kind of a balancing test as to whether the regulation goes too far with respect to limiting the economic value of use of the property, given the purposes and significance of the regulation. And so the state of California defended this suit on the basis that it really was a Penn Central regulatory taking and should be assessed through that construct. The U.S. Supreme Court, the majority of the court came in and said, no, you are actually requiring that Cedar Point, you California are requiring that agricultural employers like Cedar Point submit to a physical invasion of their property by union organizers. And for that reason, this amounts to a per se taking that would require just and adequate compensation. This has very interesting possibilities. The court says in really what I think is some dicta near the end of the majority opinion, that we're not dealing here with a case where law enforcement is going on private property to make an arrest or fulfill law enforcement function. We're not talking here about a health and safety inspector who's entering the premises under a licensing regime where the employer has consented to that inspection scheme by virtue of getting the license. And we don't think this necessarily implicates those things. But it will be interesting to see what the lower courts do with this precedent in those contexts. There are other contexts, though, where it may have a more immediate effect. For instance, think about the eviction moratorium handed down by the CDC in the midst of COVID. When you think about it, that is requiring landlords to submit to a continuing physical invasion of their property after a point in time under their lease agreements when the tenant would be authorized to legally occupy the premises. Is that a taking that requires just and adequate compensation from the government in order to put that sort of moratorium in effect? I think there are a lot of interesting possibilities for property owners under the Cedar Point case, and we'll just have to see how that develops.
Thank you. That makes perfect sense, and that's very, very interesting. While we're talking, Justice Blackwell, there's one case that had a recent decision in the October 2020 term, which is Florida versus Georgia, the water wars, which came to a conclusion via a unanimous decision of the Supreme Court in favor of the state of Georgia. Would you talk a little bit about the impact on the Metro Atlanta area and the Georgia economy?
Yeah, so the Georgia Florida water case is one that didn't break any new ground, legally speaking. Won't be a particularly important legal precedent, I think, in the long term, but is of great practical importance to Georgia and the metro Atlanta area. Most of you are probably familiar with it, so I won't go into all the details. It has a very tortured history, including proceedings in front of two different special masters. But Florida sought in the original jurisdiction of the Supreme Court an equitable apportionment of the waters flowing through what's called the ACF basin, which is the basin served by the Apalachicola, Chattahoochee, and Flint rivers. Chattahoochee and Flint rivers, of course, originate in Georgia. They flow into Lake Seminole, down on the Georgia-Alabama border, and they empty out into the Apalachicola River, which then goes into Apalachicola Bay in Florida. Florida's position was Georgia is pulling too much water out of the Chattahoochee and Flint rivers. There's not enough that goes into Lake Seminole. That upsets the salinity in the waters of the Apalachicola River and also reduces flows there. And that has harmed wildlife diversity in the Florida Panhandle, and also more particularly has severely damaged the oyster harvesting industry in Apalachicola Bay. On review to the Supreme Court finally put an end to this particular piece of the Georgia-Florida water wars by affirming the special master's determination that Florida simply had not proved any injury at all with respect to diversity of wildlife in the Panhandle. And to the extent that the evidence did show that the oyster harvesting industry in Apalachicola Bay had been seriously harmed, it wasn't clear that that was a result of anything that Georgia had done. In fact, the special master found, and the court upheld a finding, that it actually was probably much more attributable to Florida's allowing over-harvesting in the bay and Florida's failure to reseed the oyster beds in the bay. This is of special importance to the metro Atlanta area and also the agricultural industry in middle and south Georgia, because what the relief Florida was seeking in this case would have, had they gotten it, reduced Georgia's agricultural revenues by about $300 million a year. Probably would have cost Georgia another $300 million or so in additional lost productivity, and would have also limited the extent to which Metro Atlanta can continue to sustain growth because we have significant water needs that are met in part, at least, by resort to the waters flowing from the Chattahoochee. So it gives Georgia a clean bill of health to at least continue with our agricultural industry and hopefully to sustain at least moderate growth in the metro Atlanta area.
Thank you. Shifting gears, Mr. Cohn, I want to talk about the decision in Facebook versus Dagu. In that decision, basically, it surrounded the Telephone Consumer Protection Act and the qualifications that are required in order to actually have a violation of that act. Would you talk a little bit more about that opinion, which affected Facebook, and the potential for increased targeted marketing?
Oh, sure. The decision rose out of Facebook sending a text message to a telephone number based upon its data saying that this telephone number is associated with a Facebook account that said, hey, somebody tried to log into your Facebook account from an unrecognized device. And this person said, I don't have Facebook, and you're violating the Telephone Consumer Protection Act of 1991. That is the key here. 1991, when we used to pick up our telephones and they had tails that went into a wall, and we had landlines, and there were things called robocalls that were as defined in the statute, an automatic telephone dialing system that has the capacity either to store or to produce a telephone number using a random or sequential number generator, i.e. a buggy whip. This is obsolescent technology that nobody uses anymore. And Justice Sotomayor, for the unanimous court, being the strict textualist that they have all turned into, said, that's not what this is. They're not using something that dials number 1, number 2, or randomly dials number 1, number 50, number 42. This is something else, and therefore it's not within the purview of the TCPA, which takes a huge cudgel out of the hands of the consumer class action bar, much like Ramirez that we'll get to later. In terms of increased marketing, I don't think it really moves the needle much from where things are right now, because it only says that you are not making a robocall when you send a text. It doesn't address other aspects of the TCPA, and perhaps more importantly, it doesn't address all of the state court statutes. So it's a narrow ruling. It prevents the horror of TCPA liability, which is truly onerous. It could be $1,500 per violation. When in fact, there are arguments that are made by defendants in these cases that the statute itself violates the 8th Amendment because it's an excessive punishment. So that's the bottom line. Is it's a relief from the fear of something that would have caused a lot of changes in business practices. I don't think it's going to lead really to new business practices.
Okay, thank you very much. And you mentioned the TransUnion LLC versus Ramirez opinion, which deals with the Fair Credit Reporting Act. Can you talk about the significance of that opinion in the context of consumer class actions?
Okay, Ramirez is huge, and anytime you have Justice Thomas leading the 3 liberals in dissent, something interesting is happening here. It was a class action where there is a terrorist list that is maintained, that somebody is a suspected terrorist, and there are statutes that say you can't do business with this person. And this plaintiff, Ramirez, was mistakenly listed, and on this list, he went out to try to buy a car. The terrorist flag came up when they ran his credit report, and madcap mischief ensued for him, filed a class action, and the Supreme Court factually, I'll just deal with one aspect of this, said, all right, we have 8,000 claimants here who had this false record in TransUnion's database. 2,000 of them had that reported somewhere, and they have a case. 6,000 of them, it never got beyond the internal record keeping of TransUnion. And even though that record keeping was violative of the statute, they have no actual harm, and therefore they have no standing to sue. They can't be part of the class. Now, the important part of this is that the Supreme Court, as a matter of separation of powers, said, Congress, you can't legislate into being a live case or controversy. You cannot legislate a technical violation into the concrete harm that is required to maintain the a case in the federal courts. Okay, so first of all, on the class action level, if everybody has to have a concrete harm, it goes a long way towards destroying typicality and predominance in a class action setting if everybody has to individually show how they were harmed. More broadly, though, the Supreme Court has said, Congress, you could pass a law that says somebody has $1,000 statutory damages if something is technically done wrong, but if you can't show that it actually harmed them and the threat of future harm generally is not enough, we're not going to hear that. Well, that doesn't make the cause of action go away. It means that everybody's